Section, I presume you mean that the amendments to the section are out of order.
Oh yes, of
rather
course,
than section 86 being out of order.
Which one do you want to?
I want to speak to section 86.
Section
86.
86. Okay.
Yeah, okay. Thank you very much.
So we'll just turn back.
Yeah.
So it hasn't been adopted as yet.
Yes. Okay. Thank you very much. I want to speak to the section. There are no amendments. I have to say I'm disappointed that the amendment that I had has been ruled out. I thought it was perfectly reasonable and was very related to the section that is in there already and to the purpose of this bill. And I suppose I can outline in a second, but I will be seeking to further clarification on that. Clearly, extradition plays a very important role in policing and justice, both east-west and north-south, and there must be provisions for, in the context of the European arrest warrant no longer applying, in the context of a hard Brexit. Clearly, there is a need to respond to that and to ensure that that there is extradition provisions. There is far more integration and cooperation on justice and security matters than there ever has been before, and that's right and proper. Some of that is based on conventions, international, some of which are beyond just Europe, but many of these are based on EU infrastructure, and unfortunately these may have been substantially eroded. And I suppose an example of that we just came across this morning is the fact that in a hard Brexit context, the Brussels II convention, or agreement, which applies to mutual recognition of arrangements in relation to family law circumstances, will no longer apply. Now, I understand that a number of other provisions, including a Hague Convention, will cover that, but there is the possibility for divergence later on down the line. So I think that's an area that does need to be addressed. But it is coming across a wide number of areas. I know the Minister has said he's going to deal with some of them through statutory instrument. This is an area that requires primary legislation. I'd also highlight we could potentially have benefited from, even though it is not yet in force, the mutual recognition of probation judgments and decisions regarding probation and community service. Unfortunately, the new EU proposal, which we are currently transposing into Irish law, will not now benefit those who are convicted and given a sentence that involves probation in the north, for example. They cannot serve the sentence in the south if they are resident there, and that applies again east-west also. So I would ask the Minister that, while obviously it's not possible to apply that because it is not currently law, but that when that becomes law, that the Minister would seek bilateral mutual arrangements or whatever is possible with Britain to ensure that those provisions can apply. This particular section, the extradition legislation, brings us back to the Act of 1965, which is based on a 1957 Council of Europe Convention. Section 8 of the 65 Act can apply where the state has made an agreement with the country or signatory to or a country that is a signatory to a convention, such as the 57 Convention, that the state is a party to. The amendments that we put down were to ensure that this would apply to these amendments to the legislation will ensure that this applies to Britain post-Brexit and also applies for more up-to-date electronic means and efficient means of processing the application. We won't oppose that. However, the amendment we tabled sought to ensure that this legislation would remain up-to-date in the context of any changes in human rights compliance in other European jurisdictions. All continental European countries, except, I believe, Belarus, are in the European Convention on Human Rights. It has been defined as a key value of Europe and is frequently referenced in EU literature, even though it is a Council of Europe document rather than EU one. Now, the current position of the British government is to rule out withdrawal from the European Convention on Human Rights. But that has not always been the position of the Conservative Party, and there are many people within the Conservative Party who would have Britain renounce and exit the European Convention on Human Rights. I believe we need to take that into consideration, provide for it, and ensure our legislation is robust enough and can be revised if what I describe happens and the standards of human rights that pertain in the UK or any other European country recede because of a desire to reduce the human rights protection. That applies in this section, but it also applies to any areas of mutual cooperation, including, and I'll come to the issue of refoulement, if there is a departure from the European Convention on Human Rights that has very profound implications for Ireland, particularly on a north-south basis, but in general, and in terms of compliance to the highest human rights standards, north and south. As I say, the Brexit process has maybe, during the process of that, it has dropped for the moment the position that existed, what was a clearly stated policy of the Conservative Party to repeal the Human Rights Act 1998 and replace it with the British Bill of Rights, and to eventually withdraw from the ECHR. Repeal of the Human Rights Act, which brings the European Convention of Human Rights into UK law and requires British judges to take the decisions of the European Court of Human Rights into account, has been a stated aim of the Conservative Party for over a decade. It was in its 2010 manifesto, and it was clear in that manifesto then its commitment even to withdrawal from the European Union. In 2014, the Conservative Party published its proposals for a British Bill of Rights to replace the Human Rights Act. And indeed, after the 2015 general election, the Justice Secretary, Michael Gove, promised proposals on a British Bill of Rights to repeal the Human Rights Act. So, clearly, at one stage, Theresa May favoured renouncing the European Convention on Human Rights. Michael Gove favoured renouncing the European Convention on Human Rights. Several other very serious and senior Conservative leaders have favoured that position before. If that were to happen, it isn't the position of the British Government now. The Minister, I'm sure, will state that, but I'm perfectly aware of that. But we cannot say that that will remain the case, and we must, in that context, be willing to look again at our legislation, our procedures, in the manner that we cooperate with and work with the UK to ensure that our legislation is up to date. As I say, I was disappointed the amendment was ruled out, because all it required, actually, when you look at it, it amended it, and it required that where a European country notifies the Secretary-General of the Council of Europe under Article 58 of the ECHR, which is the relevant section, they are required to give 6 months' notice. All it required was that the Minister will initiate a review of this legislation that shall be concluded within 4 months, which would allow an additional window for any urgent legislative action. So, obviously, that's not being tabled now. I hope that perhaps an amended version will be in a position to be discussed in the Seanad, but I think it is an important matter, and not only in this area, but we need to ensure that we are watchful for Britain's compliance with the ECHR.
No.